fight over black voters and white Republicans continues. Yesterday, the Supreme Court heard the case out of South Carolina that dealt with how black voters have been, moved all around, impacting their role in one of the congressional districts there. After the oral arguments were heard, it was led by the NAACP Legal Defense Fund, Taiwan Scott, who was a plaintiff, spoke in front of the court.
Taiwan Scott is my name. I'm from Hilton Head Island, South Carolina. I'm the president of the local chapter of National Action Network on Hilton Head. And believe it or not, I met Janae here at a convention in 2016. And I'm so proud that she listened and she answered that call. And I'm here today because of the connection that we've had throughout these years. We need a voice in South Carolina. We need representation in South Carolina. I'm part of the Gullah Geechee Cultural Heritage Corridor, and our lands are threatened. We need an advocate. We need someone who's going to speak up on our historical concerns. And I'm praying and I'm hopeful that this is the beginning of having our voices back. Thank you.
Good afternoon. I'm Brenda Murphy, president of the NAACP South Carolina State Conference. And I want to say to you that I'm glad we're here. This has been quite an experience because we live it every day in terms of what's happening in South Carolina. Our voices have been minimized, diminished, and if you look at South Carolina and what's happening throughout the nation, we know that black people are having a very challenging time now in terms of their rights. Not only districts, but all which has a lot major implications in terms of who represents you, but also other challenges that we are faced with and we are dealing with that relate to education. It's all interrelated. Whoever is your representative needs to know what your needs are. They need to be there for you. They need to hear you. And we have not found that to be true in South Carolina. We hope when we get back, hopefully we have, a decision on what the outcome will be. And hopefully it will be the right decision that the justices support the district court in terms of what their decision was, and it was the right thing. Those lines need to be redrawn. If it's a true democracy, votes count for every single person, So we need to be represented. I want to thank some folks. First of all, this process has been over 2 years. It didn't just start, okay? We started a coalition in South Carolina, which included ACLU South Carolina, ACLU National, LDF, and we worked together. So when it was time for litigation, we knew what we needed to do or what had to be done, and we had the resources there already that knew what the challenges were. So I want to thank them as well as my NAACP General Counsel representative that's here, Attorney Anthony Ashton. They've been out beside us as well. They are part of this, and they have supported us in terms of moving forward with this movement, I'll call it. But again, thank you, and we're looking to better things in South Carolina. But you know what? If it doesn't happen, we're going to continue to fight forward.
Leah Aden is senior counsel for the NAACP LDF. She argued the case for the Supreme Court. She joins us right now. Leah, glad to have you here. So before I get to my question, just your assessment as a person standing there having to answer those questions, your assessment of yesterday's oral arguments.
I remain optimistic despite the tough questioning. It's a tough issue, the relationship between race and party in our country, but we have a unanimous panel decision and we're defending it. And we believe that the panel was correct on the law and correct on the facts. And as civil rights attorneys, we remain very optimistic and hopeful that we will get justice.
When you say a unanimous panel, explain that to the audience.
Sure. So this is a challenge to South Carolina's congressional map. There's 7 districts. One district is famously represented by Representative Clyburn, but the district at issue in this case is on the coastal part of South Carolina, anchored in Charleston. And a 3-judge panel, 3 judges, 2 of whom are based in South Carolina and know the law of the land and the facts on the ground, assessed 8 days of trial of evidence, more than 600 exhibits, listened to testimony from about 40 witnesses, some of them live in person, and determined that there was racial discrimination in the design of the coastal Charleston-based district, and determined that map makers moved more than 30,000 Black Charlestonians out of CD1, their home district, and dumped them into the adjacent CD6 that was already serving Black voters as a substantial majority Black district. So that is what I mean by a 3-judge panel. This wasn't 1 judge. This was 3 judges. All of them agreed that there was racial discrimination in this map. And on appeal, there should be a lot of deference by these 9 justices to what those 3 judges did, because it's their job as the trial court to look at the evidence and determine whether it shows a violation of the law or not.
Publica did a story stating that Congressman Jim Clyburn tried to protect his district by having more Blacks added to the district. Some have suggested that that is going to play a role in this, but really does it? Because what you're talking about is at the end of the day, it was left up to the South Carolina legislature to actually redraw those lines. And so whether Blacks were added, it doesn't matter, because that impacts just the voters. So the law is based upon not what a politician wants or desires, but the impact on the voters.
Yeah, it would be a wrong reflection of what actually happened in the legislative process to blame the enacted unconstitutional map on Representative Clyburn. He submitted an amicus brief in the case that detailed his very limited role in the design of Congressional District 1. He was, as any politician would, interested in the design of CD6 that he has represented. And more importantly, the panel of 3 judges determined that the way that the enacted map treated some historic Black areas and precincts in historic neighborhoods did not look like the way that Representative Clyburn had treated those neighborhoods in one of the proposals, a proposal that he offered during the legislative process. So we should be focused on the actual decision makers who were a nonpartisan line drawer for the state. We should be looking at the lead sponsor of the enacted map, and we should be looking at the people in the room who were Senate staffers for the South Carolina legislature, and they elected to predict the political outcome of CD1 using race data. And in so doing, they moved 30,000 Black Charlestonians from their home district. Black Charlestonians work and live in Charleston, but they're now assigned to a district where some of their neighbors are more than 100 miles away. That's not how redistricting is supposed to be done. And just last term, the Supreme Court said that you can have a legitimate interest in diversity, but you can't get there illegitimately. We believe that you can have a legitimate interest in trying to keep yourself in power, but you can never do it on the backs of Black people. And the Constitution has said that and has been interpreted to say that time and time again. And that's why the court should not reverse what the panel did here.
So this court here, this John Roberts court, they previously decided that the Supreme Court has no role in partisan gerrymandering. But they have ruled on racial gerrymandering. We saw that in the Alabama case. We're seeing the Louisiana case. You've got trials in Florida, in Georgia. We've seen this happen in North Carolina. And so a lot of the questions yesterday were sort of like, well, where's the direct evidence? But your reply was, wait a minute, you're the same court that previously said it doesn't require direct evidence.
That's exactly right. And more as a practical matter, the panel of judges recognize who admits that they are discriminating in the 21st century would be very rare. And so to hold civil rights plaintiffs up to having to prove through an admission or through some hot document that we stumble upon where people admit what they're trying to do, that would put such an unfair advantage on our ability to prove what the overall evidence shows through circumstantial evidence, which is that race was a better explainer for the design of the lines than partisanship. While partisanship was admittedly part of the decision making, it was done once again on the backs of Black people, and that is prohibited by our Constitution. And this court should not allow or send a message that that's permissible, even in the pursuit of a partisan goal.
So this, and again, in looking at this map, so let's say those 30,000 African Americans stayed in the 1st Congressional District. That doesn't make it a Black district, correct?
Correct. It only what we're asking for in our case is just to be for Black people to be treated like their neighbors, where their neighbors were treated as if they were individuals, and Black people were treated as if they were this block of people to be moved from one district to the next. And our Constitution once again prohibits that. But there's no particular outcome that we're seeking. We're not entitled to a particular outcome. We are asking to be treated fairly in the process of redrawing maps, and that wasn't done in this case.
And so what I found to be interesting, this whole idea of the questioning, saying, well, I mean, you can't leave out that this was partisan. And as I listened to it, how I interpreted it, sort of sounded like, well, Leah, I mean, we know those Black people are going to vote Democrat, so clearly this was them moving Democrats and making this more Republican, but the law is clear. It doesn't matter if they're Democratic voters, they're also Black. And you don't know, I mean, you could say, we'll assume how they're going to vote, but that was sort of interesting to me when I heard that sort of line of question.
There are two important things about that. First, the evidence reflects that if they were just worried about removing Democrats from the 1st Congressional District, then you wouldn't have the evidence that we established, which is that Black Democrats were treated differently than white Democrats. They targeted the precincts with the most Black voters in them because they presumed and predicted how they would vote, but they did not target the precincts with white Democrats in it in the same way. That's discrimination, because what's happening there is party is neutral and race is what's different, and they treated Black people differently. The second is that, unfortunately, under our law right now, you could design a district based purely on partisanship, if that's possible to do that. You could use pure partisan data to try to predict how people vote and draw a map where you're only looking at indicators of partisanship. Our Constitution permits that, or at least as our federal court has interpreted right now, that's permissible. But what we proved here is that they were not looking at voting behavior data to assign people. They were looking at race data and assuming how Black people would vote based upon their race. And that is been from the most conservative to the other justices on the Supreme Court, that is not allowed. And that is what we showed the district court, and that's what they unanimously found, which is why this decision should be affirmed.
So, and for people who are not familiar with how this works, I mean, obviously this is October, but we may not get a decision from this court until, what, May, June? Or do we expect to get one earlier? Because the reality is their ruling is going to impact whether or not the lines have to be redrawn in time for the primary season next year. South Carolina, the Democrats have moved up the primary. They're now first in the nation. They go in January. And so this Supreme Court ruling is going to have an impact. So is it possible that we actually might get a decision from them a lot sooner than we normally would?
It's definitely possible. The parties, the state and us as plaintiffs, have asked for a decision in early January, if not before, because we believe that we are entitled to a remedy in time for next year's election. There's already been one election under this unconstitutional map, which means Black people have been denied fair access to participate in at least one election, and that's one election too many. So we're optimistic that they will get a decision and we will have time to remedy the harm that Black people are enduring in time for next year's election.
And we actually saw that in Alabama, and Louisiana, where the Supreme Court froze in place those districts. And I mean, if we want, we can throw in even Florida. And so the problem here is that illegal, and I think even in Ohio, same thing was happening. So we had a 2022 election with illegal districts. Here we are coming up on 2024, and I get a kick out of people in Louisiana who are like, "Oh, I don't know if we're gonna have enough time to redraw this." It's kind of like, "Oh, so you want Black people to wait again, another election cycle, almost 4 years because it's illegal?" So that's what's at stake. Yeah. And we also know and understand that depending upon how this case goes, how Louisiana goes, Florida and Georgia, that plays a crucial role in who has control of the House of Representatives. So this is a huge, huge decision by the Supreme Court. Go ahead, final comment.
Absolutely. And I would just want to be clear that our case is a constitutional case. It's not being brought under the Voting Rights Act like the Alabama and Louisiana cases, and it's distinct from the Florida case that's being brought under state constitutions. But I do want to acknowledge that you teed off cases from the Deep South up to the Midwest, and across the country we're seeing racial discrimination in the design of the districts that allow us or don't allow us to have the chance to elect representatives who will speak to the vital issues that are important to our communities, from our schooling to our roads, to health, to environment, to reproductive rights. And this is why this fight is worth it. And this is why we are committed as an organization and obviously as a community to keep fighting, because these decisions are too important, and we have a right to have a voice in every election on a fair basis.
All right, Leah Aden, Senior Counsel for the NAACP LDF. We appreciate it. Thanks a lot.